Appeals of Tennessee is now in session. God save the United States, the state of Tennessee and this honorable court. Please be seated.
Good morning, everyone, and welcome. We're very pleased to have all of you with us. We have 3 cases on the docket. We will call them in the order in which they appear. Each appellant and appellee has a total of 15 minutes to present arguments. The appellants have the option of reserving up to 5 of the 15 minutes for rebuttal. So when you come to the podium, after you've introduced yourself, please let us know how much time you would like to reserve, and the clock will be programmed accordingly. We are very honored to have in attendance today the Tennessee Bar Association and their program called Boot Camp for Appellate Practice. And so we have a much nicer audience to observe arguments today. So counsel, those of you who are arguing your case, you will have a lot of judges in the courtroom. 3 of us will decide the merits of your case, and the other judges will decide the quality of your presentation. So no pressure, no pressure whatsoever. After the second case, we'll take a very short recess because we have to exchange members of the panel. Then at the end of the morning docket, after the third case, all 4 judges will sit up here and will participate in a question and answer with the members of the Tennessee Bar Association Boot Camp. That discussion is open to all who are here, so if you want to hang around for that, you are absolutely welcome. As we've shared with Mr. Sauer and Mr. Word, they will field any questions as long as they do not pertain to the cases that are argued today. So that's the only subject that's off limits. Of course, we reserve the right to say no comment to any other questions, but we'll go from there. Are there any announcements? Hearing none, please call the first case.
J.R. Wilfong versus Charles R. Kaelin, Jr.
All right, you are welcome to come to the podium, and we are all ears.
Okay, and I would like to reserve 5 minutes of my time for the rebuttal.
5 minutes, very good.
If I can prepare myself first and get my cases spread out.
Take your time and get organized.
Okay, I'm ready.
All right, sir.
And may it please the court, my name is Angelo Huang from the Wilson County Bar, and I represent the appellant J. Wilfong in this. And this case is an interlocutory appeal from the Chancery Court of Wilson County. The issue is whether the trial court erred in determining that it cannot order a retrial on just the issue of punitive damages only. And so this is quite a lengthy and convoluted case that's been going on in Wilson County for almost 10 years. There was a trial that was conducted in September of 2017, and the jury awarded a verdict of $750,000 compensatory damages plus legal fees, along with an award of $900,000 of punitive damages. After the hearing, the court affirmed the compensatories and also confirmed the punitives. However, the other side brought up an issue during their motion for remitter and motion for new trial that the Hodges factors weren't complied with. So the chancellor looked over the cases, the orders and the transcripts and determined that, in his opinion, the Hodges factors weren't quite teed up properly in the record. So the court ordered a retrial of the punitive damages only. And that order stayed pending for a year or two, and then the appellee brought up a case of Westmoreland, which they indicated it would be unconstitutional or unfair for the trial court to order a retrial of only just the punitive damages, and they requested that the court order a retrial of the entire case. And that's where we requested the chancellor to allow us permission for interlocutory appeal so that this court can consider the issue.
So to simplify the issues, the question is, if the award of punitive damages is set aside and there's a retrial, may the parties only focus on and try singularly the punitive damages claim?
Yes.
Or
Yes,
do
Your
you
Honor.
have to retry the entire case?
Yes, start from scratch all over again.
That's the issue before the court?
Yes.
Okay.
Yes. And the Appellee's position is that the issues are so intertwined that it's not possible to try the punitive damages issue without having a new trial on all of it. And in my brief, I've cited cases where customarily a higher court has remanded a case back down to the trial court to have a trial on only the issue of punitive damages or a retrial. And the distinction is that in this case, the trial court is the one ordering the retrial of the punitives rather than it going to the higher court and being remanded down. And also a curveball that Appellee will bring up is that if there is a new trial on the punitive damages only, it would have to be before a new jury because the previous impaneled jury is no longer sitting.
Right.
So would that cause prejudice? And our position is that no, it doesn't. The punitive damages issue can be tried without entangling or having to undo the compensatory damages. I've cited 4 places in the transcripts where over several periods, the trial court determined that the compensatories were adequate and fully supported by the verdict. My client is satisfied with the compensatories and doesn't want to undo that for the sake of having to have a new trial on all of the issues. And
Now, what we have here is, I believe the parties have focused on 2 legal principles. One is Tennessee Rule of Civil Procedure 59.07,
that's correct.
which says a new trial may be granted to all or any of the parties on all or part of the issues in an action in which there has been a trial by jury for any of the reasons for which new trials have heretofore been granted. But then we have the Westmoreland versus Tolbert case from 1990 that seems to indicate that if you're going to have to retry punitive damages, you must retry all issues. So is that the principal conflict?
Yes, that's the conflict that the chancellor in Wilson County saw, which is why he granted us permission to do an interlocutory appeal to see how those 2 reconcile. The Rule 59.07, which allows the court to have a retrial on all or part of the issues, versus the Westmoreland, which did not really clearly state it has to be done. It just suggested that for judicial economy, that it should be done in a new trial. And Westmoreland case can be distinguished. That was a peculiar situation. On the Westmoreland case, the defendant filed a motion for new trial or remitter, and the trial court remitted the punitives to 0, in which case the Court of Appeals questioned why it would be remitted to 0 on the punitive damages versus just completely granting a new trial. So this is different. Our situation, the chancellor expressed no opinion whether the punitive damages were inadequate or excessive or adequate. The chancellor just couldn't remember enough about the details of the trial in order to write up findings of facts to support the punitive damages as stated under the Hodges cases, the factors that the court found that supported the jury verdict. So that was the distinction. There was no remitted issue pending on our case. It's just a redetermination of the punitives based on the chancellor's determination that the punitives weren't adequately teed up properly according to the Hodges factors. And also, Rule 59.07 is mainly the guiding principle on the court's discretion. The Eastman versus Boyd case and Say versus Knoxville state that the court should have broad discretion over what issues or what points that it should be allowed to grant a new trial on. And although there's not an exact case that I was able to find on point on a similar issue that we have in our situation, but I did find 2 California cases that talked about whether it was unfair to have a punitive damages retrial before a new jury. And those 2 cases are cited. One is Barnes versus Superior Court, and then Bullock versus Phillips Morrison. And it's funny, the Barman's case actually says the trial court actually requested that this issue be decided by a court of appeals, since the issue of a retrial and punitive damages happens frequently enough that the trial court would like the court of appeals direction as to how to handle the situation at the trial court level, what happens in the future.
Counsel, I'm wondering here how the fact that the judge did not enter an order on the motion for J&OV impacts our ability to get to the prime issue here. I mean, it seems to me, I know you've indicated in your briefing that the judge stated orally that intention to deny that motion.
Yeah.
But, Westmoreland also stands for the principle that the judges speak, or courts speak through their orders.
Yes.
And we do not have one on that.
Yes.
And so I guess, there's always a potential that even if we ask the question, the court could say, well, you know what, I think that motion should have been granted. And then we've wasted all this time, haven't we?
Well, as you mentioned, the court speaks to its order. It didn't grant the motion, but instead it granted an order ordering a new trial on just punitives only. So that already subsumed that the J&OV would be denied, because otherwise you can't really do the punitives while then afterwards there's another JOV on top of it. So it's one of those motions that requires a positive grant rather than silence on a denial.
So we can say it's an implicit denial
It's
in this
implicit,
case.
yes.
Okay.
It's factored into the order that the court thereafter granted as to the issue of punitive damages only. So that was already reflected in the court's decision when it granted that order on punitive damages only. But back to the two California cases, we should take that as persuasive authority. The two California cases state that having a retrial on punitive damages actually gives the defendant two bites at the apple, because the second jury, if it's a different jury, can make findings that were different from the first jury on to the issue of punitive damages. So really,
Counselor, are you aware of any jurisdiction that has a flat bar on handling punitive damages in isolation on remand?
I haven't researched whether another state has that similar case. Yes, or similar type of situation. Yeah. So I would ask the court to affirm the chancellor's previous decision before this interlocutory appeal was granted, that the retrial be limited to only just the issue of punitive damages.
Thank you, sir. Mr. Hicks, good morning.
Good morning, Your Honor. May it please the court, I'm John Hicks of the National Bar and Sonia Smith-Wright, and I represent Dr. Kaelin in this case. I want to speak first to the question that Judge McBrayer posed to my adversary, which had to do with whether or not we're in a mess here procedurally because of the fact that the original motion for judgment for J&OV or new trial hasn't been ruled on. And it is clear in this record, in the records before the court, that on February the 8th of 2018, Dr. Kaelin filed his motion to disapprove the award of punitive damages or for remittiture in the alternative, and his motion for judgment notwithstanding the verdict and for a new trial. The first motion is at the technical record on page 65. The second motion is technical record on page 82. So going forward in time, the motions were discussed with the court on May the 11th, 2018, and no order was entered. Later in September of 2018, a second hearing was heard, and the court ordered a new trial on the motion for the remittiture of punitive damages and stated, following the conclusion of the new trial as to the punitive damages, the court will address any further post-trial motions. Still no order on the motion for J&OV. Later, after back and forth and the passage of yet another year, on September the 30th, 2019, the court entered the following order. Following the status conference on September 4th, 2019, the parties submitted briefs as ordered by the court on the sole issue of whether a new trial can be held on the issue of punitive damages only, or whether a full new trial must be granted as to all issues. So the court, as this court knows, as we all know, the court speaks through its orders. And the Supreme Court has held that the court speaks through its orders, not through transcripts, not through comments in transcripts, and not through other extraneous materials. The orders that the trial court entered reflect that he ruled only on the issue of the motion for disapproval of the punitive damages case and the remediator, and never entered an order. And that motion is still pending in the lower court, presumably, on the motion for JNOV. So should the court grant the relief that the appellant seeks here, what we would be forced to do is to go back to the trial court, try the case on punitive damages to a new jury, go through that entire process for several days, and then come back to the trial court and present the issues raised in the motion JNOV and another post-trial motion about credit for set-off of damages related to the settlement by other parties.
Mr. Hicks, isn't it implicit in the one decision to grant a remediature that there would be a denial of the JNOV?
I don't believe so, Your Honor. I don't believe so.
If there was a grant of the JNOV, wouldn't that be in direct contradiction of the remediature?
Not to the issue of disapproval of the punitive damages, which was the alternative grounds of the first motion. So we moved for JNOV all the way around and for disapproval of the punitive damages, or in the alternative for remediator. So what the court addressed was the motion for disapproval of punitive damages, which he clearly did. And he ordered a new trial. And after the back and forth that's been discussed, he ordered a new trial as to all matters. Because he felt, I would submit, that the matters are too much interrelated. The proof is going to be very similar, very overlapping, very much interrelated on a new trial, such that a new jury may find a conflicting answer to the questions presented.
Counsel, there's an enormous amount of weight in your arguments being placed on Westmoreland. I want to think a little bit about the timeline in terms of, and Westmoreland's a 1990 unpublished decision.
Right.
Hodges' 1992 decision that endorses a bifurcated approach with regard to how punitive damage cases are going to be handled. And then we have 2008, 2009, when 59.07 comes into effect. So how is Westmoreland continuing to limit when Hodges is 2 years later and 5907 is nearly 2 decades later in terms of the operation of how 5907 works?
I would submit, Your Honor, that the interplay between Westmoreland and Hodges is not inconsistent, because the court below found that the Hodges procedure wasn't followed in the trial below. So as a result, I would submit that Westmoreland is still valid in its analysis of the prejudice that would be involved in the overlapping proof.
I'm struggling to see how you get more judicial efficiency from to send it back to have a trial and a punitive damage stage rather than just a punitive damage stage. And the trial is necessarily going to require time, effort, energy that is going to extend beyond what would just be occurring with the punitive damage proceeding. Aren't we making this less efficient by sending it back for both rather than more?
I don't think so, Your Honor. I think that because of the interplay between the proof, because of the fact that the Hodges factors weren't met the first time, I would submit that Dr. Kaelin would be submitted subject to prejudice on the retrial, because he's going to have to try the case all over again anyway. The proof overlaps too much. As to the question about Rule 59.07, I don't think that this discussion we're having about Westmoreland is inconsistent with Rule 59.07, which admittedly did come after both Hodges and Westmoreland. 59.07 says, for any of the reasons that new trials may be granted, for any of the reasons that new trials have heretofore been granted. And in the comment to Rule 59.07, the authors reflect that those factors and those reasons for new trial are found in case law. And I would submit that 59.07 is not inconsistent with Westmoreland and the fact of prejudice, the risk of overlapping proof, in those same arguments that we've presented thus far. In this case, the trial judge is clearly dissatisfied with the verdict. There's no question about that. And virtually all of the cases that have reached this level address the issue of what happens when the trial court is dissatisfied with the verdict. In this case, in his role as 13th juror, he considered all these factors. He considered the matters presented to him. He considered the motion to disapprove punitive damages and concluded that he could not order a new trial for punitive damages only without causing some form of prejudice. And he clearly expressed on a number of occasions, both in the order granting the punitive damages trial and the order which is appealed from here, his dissatisfaction with the jury's verdict. Whatever the words used.
As to punitive damages.
At least as to punitive damages. But if the court looks at I'm going to butcher the pronunciation of the case, Wishewski case that addresses one of the cases that's cited by the appellants and responded to by us, states essentially that if it's clear to the appellate court that the trial judge was dissatisfied with the verdict, whether the court concludes that he was dissatisfied with the verdict for the right reason or another reason presented, that the appellate court should affirm the trial court's decision to grant a new trial. And
isn't the question narrower, though, before us here with the nature of this interlocutory appeal, just whether or not you can? And can you just have a new proceeding on punitive damages alone, or do we have to have a new trial on the merits plus punitive damages? Isn't the question before us narrower than whether, and we're not even being asked whether the trial judge was correct on the Hodges factor. We're just being asked whether they can order a proceeding where there's a punitive damages proceeding standing alone. Isn't that the question before us?
It could be broader. It could be that broad question, Your Honor, or it could be a narrower question. The narrower question is, can he do it in this case? And I would submit that he should not and cannot do it in this case because of the procedural posture that we find ourselves in. We would go back down. We would try the case all over again. We would present any new grounds for new trial after the retrial. And we would also address the issues now 5, 6, 7 years old in the motion JNOV that were never addressed in the first instance. For those reasons, I would submit that it was appropriate for the trial judge in this case to grant a whole new trial because of his clear dissatisfaction with the punitive damage result.
Counselor, are you aware of any jurisdiction that has a ban or bar on a punitive damages hearing in isolation on remand?
I am not, Your Honor. And I don't believe we have to go that far in this case. I believe under the facts presented in this case and the procedural posture in this case, the only appropriate decision is to affirm the trial court's decision to grant a new trial on all matters. And unless the court has further questions of me, I'm
Hearing none,
sit
Mr.
down. Thank you, Your Honor.
Thank you, sir. We'll now hear rebuttal. Oh, there we are.
And I'd like to first dispute the contention that the trial judge was dissatisfied with the punitive damages verdict. It wasn't that he was dissatisfied. The case of Hodges requires the court to make separate findings after a verdict to support the jury's verdict. So there will be separate findings of facts that the judge has as to the 8 factors, 9 factors outlined in Hodges, the defendant's financial affairs, the nature and reprehensibility of defendant's wrongdoing, impact of the defendant's conduct on plaintiff. And on each of those points, the trial judge is to go over the evidence and cite what testimony or records might support the jury's verdict on those points. And unfortunately, the lawyer who did the trial didn't quite do that. He just asked for a blanket affirmation of the punitive verdict without making separate findings. So the chancellor did not state that he was dissatisfied with the actual verdict. He just couldn't put together the proper findings of facts required under Hodges to make the record official. So that's one point I'd like to make. And also the issue of the JNOV still pending. It seems completely contradictory that the court would repeatedly say that it's satisfied with the compensatory damages part and only the punitives need to be teed up better, while still leaving open the possibility that there's still a JNOV that might address the compensatories. So again, we would argue that his earlier orders granting a retrial on just order issue of punitives already subsumes that the compensatories were fine and only the punitives needed to be addressed.
Thank you both for your arguments. We will take this matter under advisement. Call the next case, please.